Uh-oh. It stopped. All right, here we go. Hopefully, you guys can see my stream. Just checking right now the levels and everything, and if you can hear me and see me. So it seems like everything's working. Uh, what's up, everybody? This is Armando. This is the first time that I will do a mini tutorial on copyright law and some basics in copyright law. Um, I really wanted to do this because I've noticed that there was always a lot of questions as far as streaming on Facebook, and a lot of DJs and producers usually ask me a lot of these questions like, hey, why is it that my stuff gets muted or blocked? And a lot of times, a lot of DJs they don't understand the basic concepts of copyright law. So I kind of wanted to give like a background or like a little overview of how it works, or why these things happen, and what type of rights does the copyright owner have, what type of rights or defenses does the actual service provider has, and why these why things are the way they are in social media. Remember that copyright law is very archaic. It's very old school. So a lot of those terms are from way back. So the law is catching up, or trying to catch up to technology. Technology is growing rapidly. So it's very hard for the law to catch up with what's going on in real life, basically, of what's going on right now. Um, you know, as far as social media, technology, that sort of thing. So that's there's where we're at right now. Now I just wanted to see if this stream is working. Give me a minute. All right. So as I was saying before, I'm gonna give you like a basic overview of copyright law, and hopefully this is very helpful to you guys. My disclaimer, of course, is that this presentation is not aimed to give any legal type of advice or establish any type of attorney-client relationship. This is for informational purposes and educational purposes. The other thing too that I was going to tell you, for those that know or do not know, I am an attorney during the day. I know that on my social media pages I don't promote that, but what do you call it? I do that as far as the day job. Now, as far as law school, things like that, I've always wanted to practice, and I was always intrigued by copyright law. And as far as like I was always intrigued with copyright law. I always wanted to learn it, and when I was in law school, I noticed that there wasn't really that many professors that were DJs or producers. So I always wanted to learn more about copyright law, as how does it apply to me as a DJ. And I couldn't really find that too much, so I had to like just read up on the basics of copyright law, and immerse myself in it, because I found it very interesting. And obviously I wanted, as far as my DJ life, that's consumes a lot of my time after work. So I kind of wanted to do where I learn it, and at least I understand it. What are the basic questions that a lot of DJs and a lot of producers ask about this, about copyrights? What's going on here? A lot of DJs and producers, they always ask, why is my live DJ set on Facebook muted or blocked? Why? I'm not stealing anything. I bought these MP3s. I'm giving the artist promotion, so why am I being blocked? I'm not getting any money off of this. So why is Facebook muting my stuff and blocking my stuff? So that's one of the questions that we get a lot, and there isn't really that much information out there, as far as like solid answers why. Even on YouTube or the forums. It's always like all over the place because a lot of the times it's not attorneys that have that type of expertise in it, and they don't really explain it. So a lot of times it's a lot of a lot of time it's just people speaking about it, what they think it is. But so that's what the main questions that we have. The other questions that we get, or that I get usually, is how do I avoid copyright material tags when I'm streaming live? How do I avoid being flagged by Facebook? There's a lot of crazy answers out there that I've seen on on the web, on YouTube, on forums, but we'll get to that. And again, a lot of these things are not black and white. They're not yes or no answers. The law is very complex. It's usually very gray. So I know that a lot of times people want straight answers. They want to get to the point. They want something right away, like, hey, can I do this? Can I not? And the typical legal answer is like, it depends. So just keep that in mind. Now, another question that I get, the mother of all questions that I get, and I've seen it posted everywhere, is if I insert language in my live feed that I do not own any rights to these songs, I'm not gaining any profits from this transmission, will Facebook allow my live stream and video? It does absolutely nothing. No, I mean, Facebook can block it, so it's not about you putting a disclaimer out there. It's just that there hasn't, it comes to play with licensing, paying out royalties to the copyright owner. And it doesn't seem that Facebook is paying out these royalties. There isn't like a contractual agreement yet as far as licensing to be able to stream, kind of like how online radio stations could do that. I'll get more into that in a minute, but that's basically the most simple answer I can give you. The other questions that I get from producers and DJs, because a lot of DJs are now producers now because of technology, if I write my own lyrics to a song and I produce my own song by myself, do I own a copyright to my song? Again, it depends, and I'll get into it why. Other producers have asked me, or DJs have asked me, if I wrote lyrics to a song, produced a song, recorded it, can a record label I signed re-release my song without permission? That's another, it depends again. And I've seen that question posted on my newsfeed and on DJ forums. And I'll give an example of what happened in that situation. In that case, the artist made a song a long time ago in the 80s, signed to a record label. The record label 30 years later re-releases that song and puts it out on vinyl, and the artist is not receiving any money from it. So the question is, what rights does that artist have? And my answer is, it depends. It depends who filed the copyright to that song. Was it the record label? Was it the artist? What type of filing did that artist or the label filed? Is it a musical composition copyright, or was it a sound recording copyright? Or who filed it? Or did anybody file a copyright? If they didn't file a copyright, then there's no rights attached to it. So I'll get into it as far as these questions. So let me just give you the basics of what a copyright is, okay? And again, bear with me. I'm giving you concepts that way you can have a background of it. A lot of times, again, people gloss over stuff and they're like, oh my God, I feel like I'm in class. But just bear with me so you can understand the basic concepts. A copyright is basically a legal right, okay, given to originator or to an assignee, meaning a person that you assign those rights to print, publish, perform, film, record, artistic or musical material, a song, for example, to authorize others to do the same. That's in Webster's dictionary, all right? So that's not legalese, that's not, Black's Law dictionary. So in other words, it's a legal right to someone for something that you created in a tangible form or medium. A song that you burned on CD, that's what that means. A book that you wrote and that you actually wrote it out, printed it out, and put it out in a tangible form in a book. That's something that means that it's expressed, it's put together on something tangible. Okay, so what could be copywritten? Basic stuff you already know: books, poems, songs, movies, pictures, videos, movies, that sort of thing. So remember that copyright law does not protect ideas or concepts. Okay, so a lot of people think that they're like, oh, well, I thought about it first. I thought about this idea first, so I have a right to that. No. Copyright law protects expressions of those ideas or concepts. You could have an idea, but you have to put it on some sort of tangible medium. So in other words, an expression of idea can be made in a tangible medium like an MP3, a song that you burned into an MP3, or if you're old school, you burn it in a CD, or if you make a video, you burn it in a video file, an MP4 or something, or you burn it on DVD. That's an expression that is recorded. That's a tangible medium. Now, what copyrights exist in the music business? These two are very important, and they get confused a lot. So a lot of DJs ask me this, a lot of producers ask me this, and basically there's two kinds. The copyright in the musical composition of the song. That means the lyrics, the music, that sort of thing, the notes, the sheet music. That's what that copyright is if it's filed. The second one is the copyright in the sound recording, the actual recorded performance of that particular musical composition. So if you're a singer and you kind of know how to use software and you record your own stuff, you do your own vocals and you record it, then you might file a copyright for the sound recording. You actually recorded the thing. Now, the musical composition is the lyrics that you wrote down, the music, the beats, in other words, if you have sheet music, if you know how to write notes, that sort of thing. That's what that means. Now, what rights does the copyright owner have? That's very important too, because there's where a lot of the confusion lies. A lot of people think that, what do you call it? A lot of people think that, oh, well, why should I file a copyright? Well, why? What does that do? Well, the copyright gives you 6 type of rights, exclusive rights that you own if you're the copyright holder. Number 1, reproduction. I can make a song and I reproduce it and make a copy of it. Okay, that's as simple as it gets. Number 2, the preparation of a derivative work. I'm going to get into the definition of what that means. That means that I can do a song and I can make a remix to that song, to that original one. So the original song, I filed a copyright. Now I could prepare any derivative work out of it. I could make a remix to it. I could make it into from a house song to a reggaeton song to to whatever it is, Moombahton, or take your pick, a hip hop song, whatever. So that's what that means. The right number 3 is the right to distribute my song. I can distribute it. I can go to a distributor. I could go to a distribution company and say, hey, I want to press 1,000 copies of this. I want to press 1,000 copies of my vinyl. So that's what that means. It gives me the right if I'm the copyright owner. Number 4, the public performance right. That is very important. What that means is you got to understand that the Copyright Act of 1976 is old school. So it is, imagine life back then, or even before that, the Copyright Act that was in the turn of the century. So it dealt mainly with radio. So if the song is being performed publicly, like in radio, then that means that I'm entitled to certain royalties to that if I'm the copyright holder. Public performance means that if that song is being performed in a bar, in a restaurant, in a concert, that sort of thing, that's the type of right to public performance. So that's why that copyright is very important. If I don't have that right, then I can't perform it. I can't perform it if someone else has that copyright. Okay. So public display, that usually applies to paintings, that sort of thing, or maybe movies, things like that. Number 6, public performance in a sound recording in a non-exempt digital formats. Basically, all that means, I don't want to confuse you guys, but public performance in the actual MP3 that is being streamed. That's all that means. So it is new because obviously the laws changed because technology changed. So copyright law is trying to catch up to technology, because in 1976 there was no MP3s the way that is now, and they didn't have the internet the way we have now, and we didn't have streaming like we have now. So these things had to come about over time. Now, we talked about derivative work. What is it exactly? Derivative work is what I was talking about before. Is that it's a work that is based upon one or more pre-existing works, such as translation, musical arrangement, movie, picture, sound recording, with in which the work can be recast and transformed and adapted. Keyword transformed, so I can make a remix to my own song. So that's what that means, derivative work. So that comes from the Copyright Act of 1976. That's the last major overhaul, if you will, of the Copyright Act. So from then, but there has been other statutes later on, like the Digital Millennium Copyright Act, for example, that had to keep up with the internet, what we have now. So remember, a lot of these concepts are old school because we're talking about before 1976, when there was just radio, records, that sort of thing. So, that's why, copyright law can be very, very confusing. Now, I'm going to give you an example of derivative work. This example, you house heads are going to probably, get a kick out of it. But let's just say that producer Jack, right? He makes a song called "When Jack Had a Groove." Jack wrote the lyrics, made the beats, arranged the song, composed the song, mastered the song, meaning he recorded in his house, he did all the mastering, got levels right and all that, and he recorded his own vocals. Okay, so producer Jack does the right thing and goes to the copyright office and files a copyright application for "When Jack Had a Groove," the song. A year later, after much success, producer Jack makes a remix of "When Jack Had a Groove," where he changes the bass line and adds a harder kick drum and blah blah. Well, the remix is a derivative work of the original "When Jack Had a Groove." Okay, that's what that means. Now, the copyright owner, producer Jack, has the right to make a derivative work of his original work and can prevent others from making their own remix. So somebody else cannot come in and sample it and make their own remix and put it out without producer Jack's permission. And if they do, they owe royalties. Or producer Jack has rights to stop that guy from putting it out, from distributing it. Okay, so that's why copyright is very important. Now, as I was talking about, the right to public performance, that's old school stuff. 1976. Before that, before the last overhaul of the Copyright Act, the right belongs to the copyright holder to control whether his or her song can be performed publicly. This public performance includes, like, say, the composition, the musical composition, right? But via on a radio station, for example, like old school stuff. We're talking about terrestrial radio stations. Remember that only the copyright holder of the musical composition can claim this right. The right of public performance does not extend to the copyright holder of the sound recording under United States law, under our copyright law. Okay, that's where it trips up a lot of people. The sound recording is the actual recording itself, the master, and that right applies to, it's a different copyright, and that usually applies to the streaming, to the MP3s, to Apple Music, that sort of thing. That's why it's a little confusing for some people. Now, why is copyright important? Well, yeah, it's the money. I mean, how does the artist collect money? How does the record label collect money? How does the publishing company collect money? That sort of thing. So royalties for each unit sold, online streams or downloads, that's where that comes in. That's why copyright is important. Without copyright, you don't have those rights. So who collects these royalties usually? Again, depending who's the copyright holder, but usually a publishing company is who the artist goes to, and the publishing company is the one that they receive some royalties for putting it out and getting these publishing royalties, right? But the performance right organizations are the ones that collect those royalties for the copyright holder. So it could be BMI, ASCAP. You DJs know who these are because you see it on records. And if you're in the business, if you're a producer, then you know who BMI and ASCAP are. It requires membership. If you're a member, then they'll collect these royalties for you. Harry Fox Agency, CSAC, I believe that they do stuff overseas, Canada, that sort of thing. And Sound Exchange also. Sound Exchange is primarily with the online streams. So I'm not going to get into how you go about it and stuff like that. But just I'm just letting you know who the players are, who the entities are, and that's who they are. So if we look at like what you know how what do these royalties look like? I mean, if I'm putting out a track, I mean, how much am I going to get? I mean, come on, Armando, just tell me the basic stuff. So I'm going to tell you the basic stuff. For webcasts, the rate is usually uh, less than a dollar, basically. So it's like 0.0017 cents per stream. So that means for a non subscription based users, okay. Now, if it's a subscription based user like Spotify, Pandora, you know how like they get you to sign up for it and you sign up for it and you pay a monthly fee. Well, that's what that means. So that rate, if I'm the copyright holder, I get less than 1 cent, basically 0.0022 per stream. So if that user subscribed, okay, so think about that for a second. You need a lot of streams for you to get some substantial money off of it. And I'm not talking about whatever deals that you did with the actual record label, because the record label or the publishing company might have like a 50-50 split where they might say, okay, well, we'll collect 50% of the royalties and then you collect 50% of the royalties. So we'll do a 50-50 split in a standard deal. So, that's another ball of wax. So just so you know, that's how it looks like. Now, who usually owns the copyright for the musical composition? Again, it depends. It's who files this thing. So it could be the songwriter of the song who wrote the song, depending if he or she files that copyright for the musical composition. Or it could be the record label who signed the artist and the vocalist, depending on what they agreed to contractually. And if the label filed a copyright for the work of under the musical composition copyright, who gets paid? Again, the copyright owner of the musical composition can get paid royalties for the song being played on traditional radio, for example. It is a public performance if the radio station plays that song. I see a lot of you guys here online. Just bear with me. I'll give you a Q&A at the end of this. That way you could ask me any questions. But going to the next topic is who owns the copyright of the sound recording. The sound recording. That's typically the record labels file this type of copyright because it's essentially the master. So remember that there has been amendments to the Copyright Act of 1976 to keep up with technology, because now in the 90s there was the internet during the Clinton years, the information superhighway, if you guys remember. So Congress passed the the Digital Performance Right and Sound Recordings Act of 1995 to address this. But the artist can still file for this copyright if he or she chooses. I mean, if the artist did his or her own sound recording, then that person can file it. You got to understand that back in the day, in the 50s, 60s, 40s, or whatever, usually artists, they would go to the record label for the sound recording because they had thousands of dollars of studio equipment to record, to make a record, to do the studio time. So back then, artists, they didn't have thousands of dollars to make their own studio. So that's why they didn't have those type of copyrights in the sound recording. They didn't have the masters. So now in 2020, we have, software, we have laptops. Now a teenager can download software on his or her laptop and produce a song and record his or her own song. So see how things are different. So now an artist can actually file their own copyright for the sound recording, not so much the label. Now, the right applies to digital transmissions of that work, meaning online streaming such as Apple Music, Spotify, Pandora, that sort of thing. That's why that's so important, the sound recording. The copyright owner, or the copyright owner is entitled to the royalties for public performance through digital means. Facebook. See, that's what the problem is. Who's paying these royalties? Is Facebook paying these royalties if you as a DJ do a live stream to the copyright holder? No. That's why they mute, and that's why they take down certain videos because of this. But I'll get to that in a minute. Sound Exchange collects these type of royalties. They kind of came along once this whole MP3 market started and streaming and that sort of thing. Now, what if I don't file a copyright on my song? Let's just say I'm a producer, I make a song, I record it. What if I don't file a copyright? I mean, I made the song, so I should have rights to it. Nobody should copy my stuff. Well, the simple answer is no copyright, no rights. I'm sorry to tell you, but that's what it is. What's fair? Is it fair? No. But it's not about being fair. It's about what's legally correct. And if you don't file a copyright, then you don't have those rights. So what if I did file a copyright? What type of remedies, me as a copyright holder, what do I have? I could stop people from using my stuff. Injunctive relief. I could go to court. I could go to federal court, filing some sort of injunction to stop it. Number two, impounding infringing items. Remember back in the CDs, during the CD days and the DVDs are becoming obsolete now, but back in the day, people would bootleg these things and sell them. Well, the copyright holder can impound those items and say, hey, give me those bootleg CDs. That's my stuff. That's my music. That's my copywritten music. Actual damages, if they go to court on it, I lost profits. Because of these bootleg CDs, I lost X amount of dollars. Statutory damages under the Copyright Act of 1976, sometimes it could be a minimum of $750. But it could be less than $30,000 depending on the circumstances. I'm not going to get into it because I don't want to bore you guys with that, but it's kind of detailed. If it's willful infringement, if the person does it on purpose, and what willful is, it's a legal term of art. It really depends, but it can be up to $150,000. Okay, so it's pretty substantial. That's why when you see those DVDs, FBI, and if you copy this, you could, you might be liable for blah 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 damages. Well, that's where that comes from. Criminal penalties, believe it or not, can be up to 1 year to 5 years, depending on the circumstances, under the U.S. Copyright Act, under Section 2319. So I'm not going to get into what exactly, but just know that that could be the possibility of as far as penalties. Now, how does it apply to Facebook? How does that apply to Facebook? Well, does Facebook have a license or permission from copyright holders to allow streams of copyrighted material on their servers? Is there a blanket licensing agreement with the labels, with the performing rights organizations like ASCAP, BMI, CSAC? To my knowledge, no, I don't think so. That's the problem. Now, does Facebook have to pay these royalties for public performance of these live DJ sets? I mean, again, it's a murky issue. Who pays it? Is it the user, the DJ that put it out there? It's like Facebook, hey, I didn't put it out there. It was my user. They're the ones putting out infringing material, not me. So, or is it Facebook because they provide the forum to allow that to happen? So that's where it gets murky. Can Facebook and the DJs use a fair use defense? Hey, this is my, I bought the MP3. I have the fair use to be able to play this song. I paid the artist. I paid the label, for that sound recording. So why can't I use it, right? I'm giving that artist promotion. So why are you muting my stuff? That's the typical question that I get, or that I see on DJ forums or posted, and people angry and blah, blah, blah. Well, that's where that comes from. Now I'm going to look into what defenses does Facebook have, or what type of defenses are out there as far as copyright law. Now, fair use defense. The way that the Copyright Act of 1976 and case law, federal case law on the topic, there's a 4-pronged test that either Facebook would, if they're sued, or if the individual user is sued, is four elements that must be satisfied, and not one of them controls over the whole thing. The courts look at all 4 factors together. Okay, so it's think about it as all the circumstances together, putting everything together. So number 1, what was the purpose or the character of the use that I used, including whether the use is of a commercial nature or is it for a nonprofit educational purpose. That's very important. If I'm not making profit off of it, and I'm not doing it in a commercial nature, then I'm using it as a fair use defense, right? Well, it depends. Again, we still have the other 3 factors. the nature of the copyrighted work. What is it? Did you put it in a tangible medium? Is it a poem? Is it is it a book? What is it? But did you print it out? Did you have it on did you make a song? Did you put it on MP3? That sort of thing. So that's kind of what it is. That factor, it usually, okay, we know what it is. It's a song. It's an MP3. Blah blah blah. Okay. The amount and substantiality of the portion used in relation to the copyrighted work. So in other words, what am I doing with it? Am I playing the whole song? Am I playing the whole mix? Am I playing the whole song entirety? Probably, yeah. I'm mixing out of it, but I'm playing copyrighted material, right? I'm playing the whole song. So now let's just say I took a 4-bar loop and I just looped a certain part of it, like just the beat drum. You know, if you can't recognize it, then it's not a substantial. I'm not really infringing on that right because I'm not using the whole song. Nobody knows what I'm using, for example. So I'm just giving you examples, okay? I'm not saying that's a be all dead all, but just so you could be aware of it. Now, the fourth factor is the effect of the use upon the potential market for or the value of the copywritten work. That's a little tricky. So that means that if let's say I put up a website and I start streaming songs, okay, well, if I'm very popular, if I become the next YouTube, then how does that affect the potential market or the value of the copyrighted work? So if, the artist or the label is not receiving that revenue from their website or from Apple Music, and now they're turning to my site instead to stream it for free, let's say, then that would affect the potential market for that copyright owner. That's what that means. So examples of fair use. All right, let's just say the author of a book filed a copyright, right? A newspaper journalist comes in, writes a critique about the book, and says that it sucks and has a lot of expletives in it. This this book is BS. The journalist puts out an article on it. Now the question is this fair use? Yes, it is. The journalist used the book, made a editorial about it, put it on the newspaper, but he didn't use the whole book. He just used part of the books and he just critiqued it. So under the fair use doctrine, that journalist could do it. And why does that come about? The reason is because in the early days, Congress, they wanted to promote the arts. They wanted to promote dialogue, critique, whether it's political or whatever it is, because that's what, as Americans, we're proud to say that we have the right to speak, to critique things, that sort of thing. So that's where that comes from. That's fair use for the journalist, okay? Now, let's see, what do you call it? As far as like artists, like an example, let's say artist X makes a song, "Don't Mess with Cats." All right, if you guys saw that Netflix, I never saw that documentary, but whatever. So let's just say that artist X makes a song, "Don't Mess with Cats," right? Artist Z makes a parody of "Don't Mess with Cats," okay, and calls it "I Mess with Cats." Artist Z is a different artist, so artist Z makes a parody of the song, the original song. Well, artist Z's use of the song is fair use. Artist Z owes no royalties to artist X. Why? Well, because it's a parody. It's a critique of the original. They're not using the whole song of the original. They're not putting out the original. They're not sampling the original per se. They're kind of doing their own version of it, making a mockery out of it. Think about Weird Al Yankovic back in the 80s when he was making fun of the Michael Jackson stuff. Well, that's fair use. There's another example too, where Two Live Crew back in the day did a parody about Roy Orbison Pretty Woman song, and they went to court on it, and Two Live Crew won because their use was considered fair use because it was a parody of the original. They're not trying to rip off the original. So that's where that comes in. Now, does Facebook have a fair use defense? Depends. Again, this is very gray, and probably not. I mean, it depends. Again, that's the legal answer that a lot of people get usually, and unfortunately, that's what it is. Law is very gray. It's not black and white as we think it is, or we would like to think it is. Now, does the DJ have a fair use defense? Probably not, because unless you're making a parody of the song or how you're using it, I mean, if you're just playing it outright, then there's it's not really fair use. Even if you're not making a profit off of it or whatever. I know us as DJs, we don't want to hear that. I don't want to hear it because we're trying to play that music, and that's what the art of DJing is that we want to play songs from other artists and stuff like that. But we're just speaking here about live streaming and Facebook. It doesn't look like the DJs have a fair use defense as far as Facebook streaming goes. Okay, if it would come to it, if there's like litigation, for example, for it. So that's why Facebook blocks our stuff. That's why some videos and stuff. I mean, some live streams because of the music that is copywritten. If those artists file the proper copyrights. Now, there's another doctrine out there that is the first sale doctrine. What do you call it? Oh, and the other question too that I had is Ricardo Sandoval asked, so if Weird Al Yankovic, if he made a parody of, like, say, Michael Jackson's song, did he have to ask for permission to use those songs? Well, this is the thing. My advice, and I'm not giving legal advice, but it is to approach the original copyright owner first and say, hey, can I use your material? And if I can, contractually, let's work something out where I pay you some sort of royalties or I pay you some sort of fee to use that song. That's the correct way to do it. But in the case of Two Live Crew, they try to do that. They actually try to get Roy Orbison to agree to it. He didn't, so they put out the record anyway. And the courts found that Two Live Crew was not liable, because it was the fair use defense. I know it sounds backwards. I mean, they tried to work with the original copyright owner, and so technically they could just walk away and not even ask for permission, and they just did a parody. And if the courts see that it's fair use, then the fair use defense would help. So now let's go with the first sale doctrine. What is it? Well, the first sale doctrine is old school. This is Copyright Act of 1976. Okay, so think about the times back then. We only had vinyl. We only had 8-track tapes. There really wasn't a way to copy stuff the way that is now. But so the owner of a particular copy or a phonograph, a record, again, it's dating back to 1976, is entitled, without authority of the original copyright owner, to sell or otherwise dispose of the possession of that copy or record. Okay, so I can buy a CD from Michael Jackson, even though he passed away, but I can resell that CD and not owe any royalties because it's the first sale doctrine. Now, if I make 1,000 copies of it, and then I start selling it, well, then the first sale doctrine doesn't apply. It's a one deal. I buy this one CD, then I can resell that one CD because I already paid for that one CD. Okay. Now, back in the Napster days, if any of you guys are too young to remember, because I know that on my friends list I have like different age groups. So back in the day, Napster was a website that had peer-to-peer sharing, and the way that they would do it is that if the users had MP3s on their hard drive, they can basically transfer it to other users, and the other users, whatever they have in their whatever they have in their hard drive, can transfer it to other users and share it. So Napster back then tried to use the first sale doctrine, saying, hey, a lot of these users, they downloaded the stuff, they bought the CD, so they have a copy of the CD and they're just giving it to somebody else or doing whatever they want, because they already bought it in the first place. Well, that didn't work. The first sale doctrine didn't apply. The Ninth Circuit back in 2001 and A&M Records versus Napster decided that no, you cannot use the first sale doctrine as a defense because an MP3 is a different format. An MP3 can be copied 1,000,000 times. So who's going to track that? How would they be able to track who got that copy, who got the other copy? How do you collect royalties off of that? So as a DJ, if he or she purchased an MP3 from Beatport or TrackSource, can that DJ raise the first sale doctrine? According to A&M Records versus Napster, no. Unfortunately, even though you did pay for that MP3, but it's not really a first sale doctrine type of thing. what do you call it? What else was I gonna say? Now, what other defenses are out there as far as safe harbor? Okay, and there's a safe harbor defense, and where does that come from? And I think this is where Facebook comes in. Now, thank you everybody that is still tuning into me. I will answer any questions afterwards. I'm almost there, but thanks for tuning in. But I will answer your question, Ricardo. Jesse, thank you for tuning in. Okay, the safe harbor defense or provision that came about the Digital Millennium Act, Copyright Act of 1998, which basically led the way for copyrights to extend to the digital age and internet. So it also limited liability to internet providers like AOL, AT&T, Comcast, and stuff like that. So basically, what it was that a lot of the record labels were RIA, they were against how the internet was just allowing this format where these songs are being broadcast on the internet and they're not receiving any sort of royalties of it. So a lot of these internet providers like AOL were saying, "Hey, I'm not putting it out. It's my users. I can't police everyone, so I'm not the one doing it." So that piece of legislation led to like a fair, safe harbor for internet providers. So it's a three-pronged test. It's number one that AOL or whoever it is does not receive financial benefit directly attributable to the infringing activity. So in other words, people that are uploading the MP3s, that AOL is not receiving money for it per stream, for example. Number two, that the internet provider are not aware of the presence of infringing material or know any acts or facts or circumstances that would make the infringing material apparent. So if they don't know, then how can they police all these users? But I'll get to that in a minute, because with Facebook, they have these algorithms that can track if a song, is under their database as far as material that is copywritten from like the big two record labels like Sony Music, like Time Warner, that sort of thing. But anyway, but remember, this is 1998, so we're dealing with technology from way back then. So number three of the safe harbor test is upon receiving notice of the copyright owners or their agents, somebody saying, "Hey, you're playing my stuff." If the internet provider, the ISPs, if they act expeditiously to remove the purported infringing material, then they qualify for that safe harbor. So it seems that to me, Facebook is using that safe harbor defense when they take down a live stream, because they're saying, "Hey, our algorithm spotted it, and because they spotted it, we're going to mute your video." So that way they can qualify under this safe harbor defense under the DMCA. That's where that's coming from. To my knowledge, Facebook does not have a blanket license to pay royalties to transmit digital copywritten works, i.e. sound recordings or the musical composition, yet. With the performing rights organizations like BMI, ASCAP, CSAC, those type of organizations. Now, Facebook uses an algorithm, again, an engine to flag these songs that are copywritten. That's why they mute the infringing stream or remove the infringing stream from the website. Now, it appears to me, and this is to me, I'm not an employee to to Facebook, but it seems like Facebook self-regulates itself before any of these record labels or performing rights organizations come up to them and send them cease and desist letters to stop the transmission of the infringing work, possibly. But it appears that Facebook is trying to be DMCA compliant. That's why that's happening, so they can qualify under this Safe Harbor Act, and that's where that's coming from. Another interesting question, and I read it also in a book recently from Alan. Give me a second. Alan Barfridge, Music Law and Digital Age, is that YouTube actually appears to have a blanket license with ASCAP, BMI, Sound Exchange, with those type of organizations, where they can stream these copyrighted materials. But you got to understand that YouTube was doing that before the license, and once YouTube got so popular, then it was in the best interest of these big record labels and performing rights organizations to just work with them to try to get royalties off of YouTube, and that's why they are where they are now. YouTube may take down a video depending on the copyright, if it is copywritten and if it flags it, and so as far as the copyright owner, the user, they can contest the flagging of the material, kind of like in Facebook, but it's up to YouTube to accept or reject it. Now, I'm going to bring this up because Facebook. An artist I know posted. I don't know if he wants me to disclose it, but an artist that I know, he posted recently that he did a live stream and he was playing his music. And when he was playing his music, YouTube flagged his material and took it down. Now the artist was like, "Hey, I'm the artist. These are my songs that I played in my mix. So why are you deleting my stuff, basically, or muting it?" Now, I'm not sure what happened after the fact. He contested it, but I'm pretty sure he was successful at it. I don't know if he is, inbox me or let me know. But the question now is like, okay, well, who owned the copyright? Did the artist file a copyright for that sound recording, or was it the record label? I assume sometimes the record label might have the copyright to the sound recording. So depending who has that copyright, then that whoever the copyright owner is can be able to use that material however he or she fits, however he or she wants to use it. So in that case, I'm pretty sure that artist, got his stuff to be played because he was the artist. He played his own tracks. Sometimes that happens. I mean, YouTube will flag something because it was from a reputable record label, and it was what do you call it, a distribution company that has a database that has worked with with that with YouTube, that has that sort of engine that can flag it. So in other words, in their copyright, it matched whatever they had in that database. So if you're the copyright owner, obviously you can use it. You could use it as you could use your own material. That's basically what it is. So again, I mean, that's where we're at right now as far as social media. So that's why it's a little confusing, because who is the copyright owner? Who owns it? Sometimes what happens is, as an aside, sometimes an artist might have a song, but they sign to a record label, and the record label is the one that filed the sound recording copyright and the musical composition right. If the record label did that, then it's the record label that has that copyright, that has that right to that copyright, not the artist, because the artist never filed it. So I know we don't want to hear that, but that's the reality. That's why a lot of artists sign with a record label, so the record label can promote them, make them big, and then that's how the record label makes their money. There's also other deals that record labels do with the artist, where they do, like I explained earlier, with the 50-50 split as far as publishing, or with their publishing company that the artist went to. It's like 50-50 split, like in royalties, that sort of thing, in a standard deal. Or they might do a deal where the record label says, "I'm going to give you an advance, artist, but we will recoup that money from whatever sales that we make until that amount equals to the advance that we gave you." That's kind of like what happened to Tupac and Death Row Records. I believe, I think they gave him an advance, and then he owed all that money. So he still owed that money because it hasn't been, so he had to make more. The deal was that they were trying to get him to do more songs to be able to recoup, the record label could recoup that advance from him. But anyway, that's a different topic. Now, what other options do I have? What do you call it? As far as like if I want to stream, my DJ set. Well, on Facebook, and I heard a lot of crazy options out there on YouTube. I heard a lot of stuff from forums, DJ forums. Some people, they would suggest to play white noise behind your live stream, That way, Facebook, the algorithm doesn't pick it up. So that's number one. And then number two is that you play the songs in a different key or something, or do key lock, and then that way the algorithm won't catch it. So that was another suggestion. I don't, and then the third suggestion was to like play it real fast or something like that, and it's not gonna catch it. I don't believe any of that stuff works, to be honest with you. And again, I'm not an expert on that topic, but I don't think that would work. But on Facebook Live, I mean, I just say play music from local artists that have not filed copyright applications on their songs yet, or have licensing deals yet with labels. Play underground music that is not as popular and might not be flagged. Now, a lot of DJs tell me, "Oh, well, Armando, I want to play. How are people going to listen to me? The crowd, they want to hear '80s classics. So I got to give them what they like. Okay, or they want top 40. They want stuff that they know. They want stuff that they hear, on the regular. They want to hear commercial artists. Okay, well, do a mix like that, you might get flagged. I mean, you might. I mean, again, the operative word again. I'm trying to tell you guys, there's no such thing as black and white, yes or no. This is absolute. It always happens. No, no, no. It depends. That's what it is. But you're less likely to get flagged if you play newer music, if you play underground music, if you play stuff that is not as commercial. But a lot of DJs, and I understand them, and I'm not knocking on them or anything like that, but a lot of DJs, they want to play stuff that people know, especially like the older generation. I'm talking about the listeners. They want to hear stuff they grew up with. They don't want to hear the newest track from last week. They want to hear stuff that they listened to in high school. So the DJ is trying to accommodate that person and have as many listeners or viewers to view the stream. So they're going to play the popular stuff, the classic stuff, the 80s stuff or whatever, 90s, whatever. So that's one option. Play stuff that is not as popular, local artists that that sort of thing. Although sometimes somebody's gonna tell me, oh well, it was my track and I got flagged anyway. Well, it depends on the circumstances. It might happen. I'm not telling you it's not gonna happen. I mean, it depends. I mean, sometimes the algorithm is crazy and it might flag you even though it's your own track and you never put it out. It has happened. What can I tell you? The other option that I have is use other platforms: Twitch TV, Periscope TV. Now Mixcloud Live is allowing you to stream without muting your stuff or without taking it down. So as far as DJs, they know this. A lot of DJs that I noticed, they've been using these platforms. Now I'm just gonna talk to you guys that are not DJs, and usually a lot of my posts are really aimed at people that are not DJs, that are regular people that just want to listen to music. My advice to you guys is, if you like a certain DJ, if you follow a certain DJ, follow them on Twitch TV, follow them on Periscope TV, download the app on your phone. It's not that big of a deal. Try to follow them on Mixcloud. That way you can hear their streams. I mean, these DJs are trying to provide entertainment for you during these times that we're sheltered down. They're trying to play for you. So, I mean, if Facebook keeps, let's say your favorite DJ plays a lot of '80s stuff and a lot of commercial stuff that you want to hear, and Facebook keeps muting that DJ, then follow that DJ on Twitch. Follow him or her on Periscope. Follow him or her on Mixcloud Live. So that way, that stuff is heard, and the DJ doesn't run into too much muting or taking it down and stuff like that. Now, what do you call it? CZR also, he said play the song backwards. It might work. I mean, it might work. It might fool the actual algorithm of Facebook. So you never know. Also, there's also watermarks and stuff like that. I'm not going to get into the whole detail about that. It's very, I'm not a tech genius, tech expert on how how these MP3s are being now transmitted and labeled exactly, but I'm just giving you general copyright basics so you guys can arm yourselves with some sort of knowledge, so you guys can better understand how the music business works and how it's working in the social media realm. Okay, so I'm not I'm not here to give you, hey, this is the way to get around it, or this is the absolute way to, or if you do this, this will it will always happen that you're not going to get flagged. No, I mean that's not what I'm trying to do here. Now, another question that I received before was that if I write my own lyrics and I produce my own song by myself and I record it, do I own the copyright to my song? It depends. Again, I mean, number one, did you file a copyright in the U.S. Copyright Office? If you didn't, then you do not own any copyright to that song. I'm sorry. Even if you wrote it, produced it, blah, 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 you didn't file the copyright, you don't own any rights to that song. Now, there's a such thing as called as the poor man's copyright from like way back in the day. This is like preceding like the 1800s, early 1900s, where if you, let's say you write a book and you mail yourself a copy of it and you postmarked it to you, then it would qualify under common law, as far as like poor man's copyright that you, but it's a weak copyright because if you try to enforce that copyright, it's going to take you a long time to try to fight it in court, and it's an uphill battle. So best practice is file your own copyright, to protect your rights. Now, again, going back to that question, if I insert if I insert language such as I do not own any rights to these songs, and I'm not gaining any profits from this transmission, will Facebook allow my live stream and video? Probably not. Like I said before, I mean, it's an algorithm. It's not a person behind the desk that is looking at your stuff and saying, oh, well, yeah, I believe this DJ, he's not using it or she's not using it to make profit and I'm not going to mute it. Or no, it doesn't work like that. I mean, I don't work for Facebook, but, I'm just telling you that a lot of these things are mechanical, and a lot of times these things are automatic, and sometimes it takes longer than others. There's users that have told me that their stuff wasn't flagged until a year later from transmission. So, I mean, you got to understand, during this shelter down, um, orders around the world, there's a lot of DJs streaming live. So it's hard to catch everybody, and that's the reality of it. I mean, we don't, it's sometimes it might be that some users might get flagged sooner than others might, later on. It all depends. There's a lot of factors involved. I just wanted to give you again a basic copyright understanding of these concepts for people that don't know, that didn't really, never really dabbled in copyright law, or is new to the to the music industry, or things like that. I just wanted to give you just what the concepts are, what are the things that are out there, and kind of what mechanisms are in place. And as far as like organizations like performing rights organizations, the different type of copyrights out there, the type of rights that you have under a copyright, that sort of thing. So I kind of wanted to do it as a service to you guys, my DJ friends and producer friends that are on my friends list, also to the regular listeners that are not DJs or producers, just to give you like a general background of it, and just to advise you guys, if you're going to follow a DJ, go follow them on these other formats. If they're on Twitch TV, Mixcloud Live, or what's that other one, Periscope TV, and that's about it. So thank you all for listening to me. Hopefully I didn't bore you guys with this tutorial. Numo Dan in the house. Who else? Let me see. Horacio, Renee, Gabriel, CZR, Victor Martinez, Gabriel Smith. Thank you all for tuning in. Lorenzo Martinez, Jesse Batista, Rick the Player, Maria Stewart, Sotero, Juan, Norman, Margarita, Yesenia, Ellie, Maddie, Garza, Chach, Kai, Lindsay, Antonio Sandoval, everyone. All right, I'm not seeing any questions, but you guys can actually inbox me if you want. If you have like any general questions and stuff like that. Xavier Lebron in the house. Also Carlos Rodriguez, Charlie Glitch. Good to see you. And that's it. So hopefully you guys found this a little bit informational. If not, then you know, no, I'm just kidding. But hopefully you guys found this informational, and hopefully it helps you guys out. And I just wanted to do something as a service to you guys, and whatever knowledge that I have about copyright law. I just wanted to share it with you guys. And as I said in the beginning of the video, when I was in law school, this really intrigued me as far as copyright law, and I wanted to learn more about it, and be an entertainment lawyer to represent artists back then. This is years ago. But obviously I practice different type of law today, but I always kept up with copyright law and stuff like that, and trademark, because it's something that kind of, it does correlate, or it does run parallel with the music industry, and these concepts, they do apply. So it's good to know these things, because especially knowing what rights you have, and also why things happen, as far as like licensing, or why does Facebook mute my stuff, or blah blah blah. So that's where we're at. And other than that, I will leave you guys with that. Thanks for tuning in, and thanks for tolerating my boring history of the Copyright Act. I wanted to make it as more entertaining as possible, and not as boring as like when I was in law school and I was just hearing hours and hours, and I was like, look, man, how does that apply to DJing? How does that apply to producing? That's all I wanted to know back then, and I'm sure a lot of you guys, that's what you guys wanted to know too. So thanks for tuning in, and with that, I say goodbye.